Please be seated. The Secretary will read the order.
Debate on vote number 22, Office of the Chief Justice and Judicial Administration Appropriation Bill.
I now call upon the Honourable the Minister of Justice and Correctional Services to introduce his budget vote. The Honourable Minister.
House Chairperson, Deputy President, other colleagues in the National Executive, as well as colleagues from both sides of the House, may I take this opportunity to greet you all and thank you for joining us on this occasion of discussing the budget vote for the Office of the Chief Justice. It is an honor and a great pleasure to present to this august House the budget policy statement of the Office of the Chief Justice, OCJ, at this occasion of the 3rd anniversary of the separate budget allocation for the office. As I introduce the debate, allow me to first join President Jacob Zuma in congratulating Honorable Chief Justice Mogoeng on his election as President of the Conference of Constitutional Jurisdictions of Africa, the CCJA, during its 4th Congress, which was held on our shores in Cape Town in April 2017. By bestowing the leadership of this important continental body to our Chief Justice is not only an acknowledgement of his judicious stewardship, but is also an affirmation of the significant role that our judiciary continues to play in the development of global constitutional jurisprudence. We wish him well in this important role. This year marks an important milestone in our fledgling democracy as we commemorate the 23rd anniversary of the ushering in of constitutional democracy on our land. Chapter 8 of the Constitution, which deals broadly with the justice system in the country, defines the role of the cabinet member responsible for the administration of justice. The Constitution entrenches the independence of the judiciary and the courts, which function subject only to the Constitution and the law. The legislative and executive branches have a constitutional duty through legislation and other means to assist and protect the courts in carrying out this delicate and more often complex constitutional mandate. The role of the judiciary becomes even more vexed when the courts are called upon to adjudicate upon disputes that fall outside the province of the courts, which lately is becoming a common phenomenon in our litigation space. When adjudicating over such disputes, it is expected of the courts to exercise judicial restraint within the defined parameters of the Constitution and must resist the temptation of overreaching into the terrain of other spheres of our democracy. The historic meeting of the National Executive and the leadership of the Judiciary of 27 August 2015 created a conducive platform for constructive engagement amongst the branches of state on matters that straddle across each other's constitutional mandates. Before I step off this matter, let me take this opportunity to appraise this esteemed House of progress made by the Interministerial Committee led by the Deputy President, and I once again want to acknowledge his presence in this House. Deputy President Cyril Ramaphosa, which was appointed by Cabinet to spearhead the development of policy and legislative reform on judicial governance and court administration. The Deputy President has already met with the Chief Justice to elicit the views of the judiciary on the subject, and a technical task team led by the Director General of Justice is undertaking guided research on the matter. The work of the Interministerial Committee will culminate in the desired policy and legislative reforms that will define the ultimate governance model for the judicial branch of the state, especially in relation to the delineation of roles between the executive and the judiciary in the administration of justice. The reforms will also clearly delineate judicial functions, which are the preserve of the judiciary on the one hand, and meticulously address the question of accountability over court performance on the other. Honorable members, the judicial system is at the heart of the criminal justice system, and the effective and efficiency of the system is measured through what happens in the courts. Courts have an indelible role in our quest to restore the public trust in the criminal justice system, which, judging from the myriad of challenges facing the system, appears to be spiraling downwards. Through the Constitution 17th Amendment of 2012 and the Superior Courts Act of 2013, the Chief Justice exercises the responsibility over the norms and standards for performance of judicial functions. We derive comfort from the work of the National Efficiency Enhancement Committee, the NEEC, and the Provincial Enhancement Committees, the PECs, established by the Chief Justice as the coordinating and oversight structures in finding solutions to these challenges. From the side of the executive, we are devising a mechanism through which we're able to complement the work of the NEC and PECs where specific interventions by the executive is required. I will report in greater detail when I present the budget policy statement of the Department of Justice and Constitutional Development tomorrow for the approval. I will present a full statement for the approval by Cabinet of the Integrated Criminal Justice Strategy, the ICJS, tomorrow when I deal with the budget of the Department of Justice, which was approved by Cabinet recently, which aims to adopt an integrated approach to addressing challenges facing the criminal justice system from start to end. We are looking forward to seeking active participation by the judiciary on the ICJS in our collective endeavor to establishing an effective and efficient criminal justice system for South Africa. Honorable members, the Judicial Service Commission continues to relentlessly in its endeavor to realize the constitutional imperative expressed in Section 174(2) of the Constitution, which alludes to the code that the need, for the judiciary to reflect broadly the racial and gender composition of South Africa, end quote, when judicial officers are appointed. It is commendable that out of an establishment of 246 judges, 160 or 65% are black, and 86.3% are 86 or 35% are white. I thought I couldn't get that one right. While the Commission has been resolute in rejecting nominations which do not advance gender transformation. The reality of the matter is the absence of an adequate pool that will enable a critical mass of candidates that are required to reverse the historical imbalances, especially in relation to gender transformation. Women on the bench constitute an awful 87 or 34% of the total number of judges 23 years into our democracy. The Chief Justice has raised with me the desirability of resuscitating the Aspirant Women Judges Project, which was initiated by the then Minister Bridget Mabandla and the late Chief Justice Langa. Through this project, an intake of eligible women practitioners will be put through a judicial training program under the auspices of the South African Judicial Education Institute, and are given exposure on the various judicial work areas, thereby enhancing their opportunity for appointment to the bench. I am considering the Chief Justice's request favorably and will make an announcement in this regard in due course. The nomination by the President of the first ever woman to the position of President of the Supreme Court of Appeal, who is also Black African, namely Justice Mandisa Maya, is a cause for celebration. I also wish to congratulate Honorable Justice Zondo on his nomination to the office of Deputy Chief Justice of the Republic of South Africa. May I take this opportunity to thank Justice Nkabinde for her continued enthusiasm and sterling work done as acting Deputy Chief Justice. Let me further express appreciation to the two judges President, Khomo and Sangoni, of the Northern Cape High Court and Eastern Cape High Court, respectively, who will retire in the current year. Honorable members, one of the important functions of the Judicial Service Commission is to ensure judicial accountability. The Commission is seized with a number of complaints against judges which have taken time to complete. This requires that we engage with the Chief Justice and the Judiciary to look at the effectiveness of the current complaints handling mechanism. The complaints range from delayed judgments as well as alleged racist remarks. As part of the effort to safeguard the fundamental constitutional principles of judicial independence and accountability, the Registrar of Registrable Interests located within the OCJ is seized with a responsibility of registering the registrable interests of judges in active service as required by law. All judges in active service by 31 March 2017, I'm pleased to report, have complied with the requirement period for disclosure, except one who could not do so because she was ill-disposed. Honorable members, on 25 January this year, the Limpopo Division of the High Court completed a year since it commenced with its operations in January 2016. The court role of the division has shown steady increase since its coming into operation. We are on course to complete the construction of the Mpumalanga Division of the High Court by the end of the current financial year, as was announced by the President during the State of the Nation address in February this year. This milestone is proof of our concerted effort to realize the goal of establishing a high court in every province in the Republic. in line with the current constitutional arrangements. The Judicial Services Commission has at its recent sitting last month recommended to the President the appointment of Honorable Mr. Justice Francis Lekhodi as Judge President of the new division for Mpumalanga, and we look forward to his possible or likely appointment. Upon his appointment, Judge Lekhodi will, in the interim, Judge Lekhodi will oversee the transition and operationalization of the court. The opening of the court in a year's time will symbolize the switching on of the light in the terrace of justice in the province, thereby bring to an end a long and painful journey that the people of the province of Mpumalanga had to endure in commuting to Tshwane in search for justice for over a century. Honorable members, we have recognized that the education and training of judicial officers is necessary to promote and uphold the independence, impartiality, accessibility, effectiveness, and competence of the courts. In this regard, the South African Judicial Education Institute, located under the Office of the Chief Justice, continues to offer training courses to judicial officers. During the 2016-17 financial year, 90 judicial education courses, which include basic and advanced courses for newly appointed magistrates and aspirant judges, were offered to serving and aspiring judicial officers, which exceeded the set target of 70. In this 2017-18 financial year, the number of judicial education courses to be offered by the South African Judicial Education Institute is rising to 77. Honorable members, there has been a steady increase in the personnel of the OCJ to from the initial 1,486 staff members transferred from the Department of Justice and Constitutional Development. The employee headcount now stands at 1,700 staff members in that office. This increase was informed by the need for more staff to support the judiciary in the performance of its administrative functions. More capacity will be added to the OCJ as soon as we finalize consultations on the OCJ macro structure. I wish to inform this August House that the expenditure on the 2016-17 budget at the end of the financial year stood at 98%. The budget spending was in line with the allocation and budget prescripts, meaning there was no overspending. It is commendable to note that the department had an unqualified audit outcome on the financial statements in the maiden year of operating the budget vote. This indeed should be commended. Over the 3-year medium-term expenditure framework period, the OCJ has been allocated a total budget of 6.32 billion rands. For the 2017-18 financial year, the allocated budget amounts to 1.98 billion rands. Of this amount, 966.06 million rands is allocated to judges, remuneration, and benefits. This means that the OCJ will have an operating budget of 1.018 billion rands. Of the total budget, 737.47 million rands, which represents 77.3% of the budget, is allocated to judicial support and court administration. Judicial support and court administration has been allocated the bulk of the budget as it forms part of the key mandate and core business of the OCJ. These funds will be utilized to improve the court system through an effective and efficient case flow management system and the capacitation of the OCJ provincial centers, which will provide administrative support to the superior courts. The funds allocated for judicial training of judicial officials has increased from 30.2 million rands to 49 million rands in 2017-18. A total amount of 154.94 million rands has been allocated to conduct about 246 judicial education courses over the medium-term expenditure framework period. The budget for administration of the entire OCJ amounts to 198.99 million rands, which continues to 19.5%, constitutes 19.5%. I acknowledge the tight fiscal environment within which the country currently operates and the difficulty decisions that the National Treasury needs to make to divide the limited resources against competing priorities nationally. And therefore, we appreciate the resources made available to enable us to support the judiciary, and I commend this budget for the House consideration, favorable consideration. I thank you.
Thank you, Honourable Minister. The next speaker is the Honourable Mocheka.
Honourable House Chairperson, Mr. Cedric Froelich, Honourable Deputy President, Mr. Matamela Cyril Ramaphosa, Minister of Justice, Honourable Michael Masuta, Deputy Minister John Jeffries, Secretary General Me Sejo Sengwe, Honourable Members. The doctrine of separation of powers is the cornerstone of our constitutional democracy. The transition from parliamentary sovereignty to a constitutional state requires a radical transformation of our legal system, including formal and substantive aspects of the law. The new dispensation makes the independence of the judiciary a constitutional imperative. The establishment of the Office of the Chief Justice was envisaged as the first phase towards the independent judiciary-led court administration system in order to fully realize the judiciary's institutional independence in line with the Constitution and the Supreme Court Act 2013. The separation of powers between the three arms of the state is not watertight. It is open to interpretation by the courts and therefore seems to shift the balance of power in favor of the courts. This has raised debates on judicial activism and judicial overreach. These debates should not be used to undermine judicial independence and lead to calls for a return to parliamentary sovereignty. Our icon, Oliver Reginald Tambo, was the master architect of our constitutional democracy, the rule of law, human and people's rights. The doctrine of the rule of law, human and people's rights, in and by themselves, presuppose the powers of the judiciary to review and test the validity of the acts of Parliament and the executive. These doctrines also curb arbitrary and or irrational and unlawful actions by the executive and Parliament. They also provide definite criteria for judicial oversight on Parliament and the executive. In many young democracies like ours, the independence of the judiciary could irritate Parliament and the executive, as it declares some acts of Parliament and the executive actions unconstitutional invalid, and of no force and effect. This should not be so because the independence of the judiciary provides the checks and balances necessary to curb abuses of power and safeguard fundamental human and people's rights. The independence of the judiciary cannot be fully realized unless and until the Office of the Chief Justice is fully resourced and staffed. The OCJ and Judicial Administration receives just under 2 billion for 2017-18, of which almost half goes to judges' salaries. While the allocation increases in real terms by 2.3%, the OCJ has a relatively small budget. It receives approximately 0.5% of the allocation for public order and defense, in which it must achieve a great deal. The OCJ supports the judiciary in its contribution to Chapter 14 of the National Development Plan, promoting accountability and fighting corruption through strengthening judicial governance and the rule of law. While acutely aware of the need for fiscal restraint, we are extremely concerned about how the present funding constraints will impact on the OCJ's ability to deliver administrative, operational, and governance support to the judiciary. Of particular concern is the impact of the ceiling of the salaries budget on the implementation of the Superior Court Act. During the 2017-18 budgetary process, National Treasury implemented a ceiling on the budgets of all state entities. Application of this ceiling prevents it from being able to fill any new posts for much needed additional capacity to support the courts. The most critical area of pressure right now is the need for additional capacity to the judges' presidents. The effect of the current year's ceiling of 615 million, if it is fully utilized, is a projected budget shortfall of 16.2 million in 2018-19 and 20.9 million in 2019-20. This would constitute unauthorized expenditure and will result in a qualified audit opinion. This option cannot and is not supported. The ceiling has also impacted on the OCJ's ability to appoint staff for the new Mpumalanga High Court when it is completed later this year. There also appears to be no funds in the current budget for the operationalization of the Mpumalanga High Court, which is due to be completed later this year. The need to make provision for the operationalization of newly built courts has been raised previously. In this instance, the committee was told that the OCJ's budget proposals for 2017 MTF included a request for National Treasury to allocate the amount of 18.1 million for 2017-18, 19.2 million for 2018-19, and 20.7 million for 2019-20 to allow for the operationalization of the Mpumalanga High Court. We are informed that an amount of 18.1 million was indeed approved for the Mpumalanga High Court for 2017-18, but that budget cuts on the operational budget to the amount of 29.9 million resulted in a net reduction to the OCJ's baseline of 11.8 million. This, in essence, has resulted in the non-funding of the Mpumalanga High Court. We regard the establishment of the Mpumalanga High Court at Mbombela as a national priority and take a dim view of anything that may cause any further delays to the establishment of this court, which will be a first for Mpumalanga and is vital for transformation and the promotion of access to justice for those who live in that province. At present, the court, which has been open from 1st February this year, is housed at the Nelspruit Magistrate Court. Previously, those wishing to use the court needed to travel to Gauteng. We note the judiciary's view that English should remain the language of record to avoid unnecessary delays on appeal but parties should be able to speak their own languages in court. However, we remain firm of the view that more needs to be done to support multilingualism in our courts. It has been suggested that the legal professionals be required to speak an indigenous African language to practice, and that this be part of the legal curriculum at our tertiary institutions. We agree with that as a vocation should be properly elevated and engage further with the ministry on how this suggestion should be taken forward. The current transformation of the judiciary seems to be limited to colonial courts. There is no mention of traditional and community courts. Also, the judiciary does not seem to give the necessary affirmation to African customary law and indigenous African languages. The South African Judicial Education Institute offers some sporadic training to traditional leaders, but does not insist that the trainers themselves study African customary law and at least one of the indigenous African law. We note the judiciary's view that English should remain the language of record to avoid unnecessary delays on appeals, but parties should be able to speak their own language. This requires the introduction of indigenous African languages, requires the re-establishment of the departments of indigenous African languages in tertiary institutions, and the transformation of the curriculum of law and social sciences to make one or more indigenous African languages compulsory subjects. This will bridge the communication gap between helping professions and the beneficiaries of their services. It is unthinkable that the indigenous African people can access justice when all investigating officers, prosecutors, lawyers, and judges are English or Afrikaans speaking, and interpreters have not received any training in any of the indigenous African languages. The judiciary should incorporate traditional and community courts which are conducted in indigenous African languages and are accessible to the majority of the people, especially in rural areas. The referral of the community courts projects to the South African Law Commission is not called for because traditional courts took more than 10 years, 10 years to be brought to this parliament. Now a referral to the commission would mean that we need to wait for another 10 years before the bill comes to parliament. We believe that there is no need for special investigation into community courts by the Law Commission, because during the 80s and the 90s, enough work was done in this regard. The experiences of Zimbabwe, Mozambique suffices to aid us in developing community law courts model. So, Honorable Minister and Deputy Minister, we would want to call on you to speed up this matter because as you heard, there's overcrowding in the courts because people charged with social ills, petty crimes are cloaking the justice system. They are filling the correctional centers, and now the whole entire system becomes unworkable. We believe that traditional and community court systems will actually ensure that there's no overcrowding and that therefore justice is delivered to the majority of our people easily and fast, speedily. I thank you, Honorable.
Thank you, Honourable Member. The next speaker is the Honourable Breitenbach.
Thank you, Honourable Chairperson, Honourable Members. We live in a time when the debate on Vote 22, the office of the Chief Justice, again attracts more attention than would have been the case had we lived in a normal constitutional democracy. But then, of course, we do not. We live in a constitutional democracy described by the President, who should be one of the ultimate guardians of this constitutional democracy, as a funny democracy, and he's the only one laughing. Particularly when he displays his total inability to understand the role of the judiciary in scrutinizing all exercise of public power. But he, of course, is not alone in this inability. It is clearly an extremely contagious affliction that has spread not only through his entire cabinet, or what remains of it, but through his entire party. In his speech on this vote on the 19th of May 2015, the Honourable Minister of Justice stated as follows: "Today's maiden budget vote debate of the office of the Chief Justice marks an important turning point in 21 years of our democracy. The independence of the judiciary is crucial in view of the role it plays in a constitutional democracy within the context of a separation of powers." He then went on to quote with approval former Chief Justice Ngcobo, who remarked, "The role of the judiciary in a constitutional democracy is an expansive one. Decisions of judges affect many people. Courts have the power to overrule even the most popular decisions of the other arms of the state if they believe that they are contrary to the Constitution. The acceptance and support of these and all court decisions by society depends upon public confidence in the integrity and independence of the judiciary." So maybe the President is correct in saying that we live in a funny democracy, because what would have been funny if it was not so terribly sad is that on every occasion since then where the courts have performed exactly this function, they were roundly criticized and derided by the President and members of his cabinet in a manner that can no longer be seen as merely a discussion of court rulings, but which can only be seen as an attempt to intimidate the judiciary. Chairperson, then from the left of stage entered yet more thieves, who stole 12 or so hard drives from the office of the Chief Justice. These so-called thieves were of the allegedly common and garden variety, or at least that is what the acting Commissioner of Police wanted the country to believe, when he rounded up 3 unfortunate passers-by and tried to pass them off as criminal masterminds of the caliber of George Clooney and Brad Pitt in a South African version of Ocean's 11. What, however, remains unanswered is exactly how the real thieves, who remain undetected to this day, gained access to a building that should be totally secure, whether a CCTV camera system was operational at the time, and if so, how it was circumvented, as well as the progress or lack thereof in tracking down these real thieves. Chairperson, in all seriousness, it was with a great measure of discomfort that we learned that the budget allocation to the Office of the Chief Justice will not allow this department to strengthen security measures through their own resources. If the President and his colleagues within the ANC is really serious about the practical implementation of the separation of powers, it must follow that the Office of the Chief Justice should not be dependent on another of the arms of states for its safety measures. Chairperson, on the right of stage and present there since before this department was established in 2015 and afforded its own budget vote, remains, of course, the issue of a judicially led administration model. From the outside looking in, it would seem that the Minister of Justice approaches this issue with a theory that if he turns a blind eye to it for long enough, it will simply go away. The stance of the judiciary on this matter is clear, and since nothing real has happened to address the standoff since this debate last year, we reiterate. The Democratic Alliance supports a model through which the judiciary be allowed, in a manner similar to that of the Auditor General, to negotiate directly with Treasury regarding its budget allocation. Accountability in regard to how this budget would be spent should be enforced by a parliamentary committee set up specifically for this purpose, rather than the Portfolio Committee for Justice and Correctional Services. This unwillingness to constructively deal with the issue must be read against the backdrop of the continuous and continued criticism of the President and members of his cabinet and others within his polluted inner circle of the judiciary. From accusations that the collective mindset of the judiciary is in need of transformation, to statements that certain divisions meet with what were called characters before producing counter-revolutionary judgments, to a more specific accusation that the Western Cape and North Gauteng benches assisted efforts by opposition parties to govern through our courts. We've heard it all. After the Nkandla judgment, scathing attacks were launched on the judiciary by many in the ANC, particularly those that rushed predictably to the defense of the President, the hand that feeds them. After the judgment in the matter of al-Bashir, cabinet ministers openly attacked the judiciary. In particular, Minister Mbalula and Minister Nzimande were most outspoken. When the President addressed the House of Traditional Leaders, he told them that the judiciary was not to be trusted, that judges found one guilty for stating one's case, even when one was innocent. The attacks on the judiciary were of such an alarming scale that the Chief Justice was moved to request a meeting with the President in order to address the attacks and the effects thereof. The meeting took place, and a stone-faced Chief Justice and a predictably giggly President told the nation that the proverbial hatchet had been buried and that a new understanding had been reached, reaffirming the importance and independence of the judiciary. Yet the criticism continues. For as long as this budget does not facilitate complete independence of the judiciary, the DA cannot support this budget. I thank you.
Next speaker is the Honourable Matiase.
Honorable Chair, Mr. Frolick, our colleagues in the EFF, and members of the public in the gallery. At the onset, let me say that the battle in the 21st century is the battle of the mind, and we shall not retreat in the battle of the mind. And that battle is discharged from this podium. The Economic Freedom Fighters fully support the budget vote 22 of the Office of the Chief Justice. Contrary to the views of the parliamentary tycoons and barons on my right, South Africa is not a parliamentary democracy or a monarchy, but a constitutional democracy. Parliamentary democracy, as seen under the Nationalist Party, fascist and racist regime, is now part of the dustbin of history, just like the ANC will soon be thrown into the rubbish heap of history. We are here to contribute in the budget debate of one of the most precious of all state institutions, the judicial arm of state, the Office of the Chief Justice. We are a constitutional democracy, whether some like it or not. We are advocates of constitutional democracy because we cherish the alternative vision of the drafters of the Constitution of a South Africa that champions the basic tenets as enshrined in the Bill of Rights. But we are not entirely complete as a nation by merely embracing the supremacy of our Constitution as a supreme law, vaguely, as Honorable Motshekga has attempted to do and badly failed. And badly failed to answer the question, which ought to be asked, are we a sovereign? We must attempt to answer this question as we contribute in the discussions aimed at enriching the continuing dialogue on the transformation of the judicial system, geared to shape the policy, legislative, and jurisprudential landscape in order to strengthen our constitutional democracy. To understand sovereignty, we must go back to man's creation, and we shall notice that in the beginning, from the first instance of man's existence on earth, the Creator granted man three gifts that define sovereignty, which is dominion, agency, and possession. Thus, to understand sovereignty, we must first understand these three orienting aspects of the history of struggle and of human existence. As indicated, political and judicial sovereignty belongs only to free men and women, to free nations capable of feeding themselves, not causing sovereign downgrades and junk status, capable of making rational and sound decisions, of making contracts and entering into agreements as guarantors of their children's future. Principally, sovereignty is about the three orienting aspects of human existence: dominion, agency, and possession. Africans have none of these three. In the bigger scheme of things, we are damned. Any country which is deprived of these three orienting aspects that define sovereignty is not a sovereign. At best, it's a state being confederated and left to the whims of feudal barons and tycoons, the landed gentry, the free-rolling monopoly capitalists, and that parasitic, rotten, corrupted social scum which hangs from the neck of the poor. Likewise, we must do everything in our power to protect our country from descending into a jungle of lawlessness, syndicalized criminal impunity. We must build, strengthen, and enhance judicial independence, because judicial independence equals national sovereignty. The importance of the Office of the Chief Justice in protecting the Constitution and holding both the executive and legislature to account cannot be ignored. The OCG and the Constitutional Court should, as a matter of necessity, be seized with the following task: deepening and inculcate a new national consciousness about judicial sovereignty, a need to assess the impact of the decisions of the legislature and executive on the transformation of the state and society as a whole, and how socio-economic conditions and lives of people are affected by such decisions. These roles, should they be adhered to, will make the Office of the Judiciary and the Office of the Chief Justice as a whole the most precious arm of the state, because upon its existence rests the safeguarding and protection of hard-earned freedoms and our sovereignty amongst free nations.
Honourable Member, your time is now expired.
We as the EFF stand here to support the budget vote of the Office of the Chief Justice. We shall not retreat in the battles of ideas. Thank you, Honourable Chair.
Order. The next speaker is the Honourable Singh. Order, Honourable Members.
Thank you, Honourable Chairperson. At the outset,
Order, Honourable Member.
some injury time, Chairperson. At the outset, Honourable Chairperson, allow me once again to congratulate the Chief Justice, his fellow justices and staff on the outstanding work that our apex court, that is the Constitutional Court, is doing in upholding and keeping sacrosanct and inviolate the rule of law in this country. I shudder to think of the dire straits we would find ourselves in had it not been for our courts and their unwavering defense of the rule of law. In respect of judicial appointments, I am privileged to serve together with 5 of my colleagues from the National Assembly in the Judicial Services Commission. This body, chaired by the Chief Justice, bears the responsibility of ensuring that only fit-for-purpose judges are appointed to our high, appeal, and constitutional courts. It remains untarnished by politics, and this is testament to the character and integrity of both its chair and members. May this practice continue ad infinitum. Honourable Chairperson, with a projected budget of only 1.98 billion for the 2017-18 year, the OCJ has their work cut out for them. The administration of justice is still falling short of the mark, and this is where improvements must be made in terms of underspending on programs. These areas would include poor governance, low numbers of finalized cases, and the review and setting aside of judicial decisions. In this regard, Honourable Chairperson, the continuing saga in the Judge Nkola Motata matter demands resolution. As of last year, it has been reported that Judge Motata may have earned up to 13 million rand since his quote-unquote special leave suspension was instituted in 2007. This cannot be allowed to continue and must be prioritized for resolution. A further issue that needs our attention, and I'm glad the Honourable Minister referred to this in his opening remarks, is the independence of the judiciary, the institutional independence of the judiciary. We all know about the golden rule, Chairperson, and I quote, "He who has the gold makes the rules," close quote. So I think it's about time that a time frame is set to ensure the institutional independence of the Office of the Chief Justice, because at the moment, the money is controlled by the department. And I hope when they are reviewing this matter, they also look at why is it there a need for any judge who wants to apply for leave to apply to the minister and not to the Office of the Chief Justice when they want leave. Honourable Chairperson, the recent breach in security, which saw 15 computers stolen from the HR Office of the Chief Justice in Midrand, dealt a massive blow to the effective administration of justice. In addition, these PCs contain personal information about judges and officials. The perpetrators of this crime must be found and prosecuted to the full extent of the law. And one can only hope that this burglary was not committed by an already existing tentacle of the quote-unquote state capture apparatus. But what is most concerning and unfortunate, Honourable Chairperson, is that at a march held in Durban on Monday, the chairperson of the ANC in KwaZulu-Natal, Mr. Sihla Zigalala, said, and I quote, "There is a growing observable trend by the courts to act and play in a big brother role, where in some cases, not many, the courts find themselves encroaching on the terrain of other organs," close quote. Now, Mr. Zigalala, of all people, should know, as chairperson of the ANC in the province, that he must listen to the wisdom of people like Honorable Dr. Professor Motseka. Because when he came here, speaking on behalf of the ANC, he said that we must appreciate the independence of the judiciary and their right to make findings on whatever we do wrong. So I hope that Honorable Zigalala gets this message loud and clear.
Honourable Member,
the IFP
your
supports
time is
this
now
budget
expired.
vote. Thank you.
Thank you. The next speaker is the Honourable Ngwabe.
Honorable Chairperson, honorable members, distinguished guests, practicing lawyers in the gallery, good afternoon. The judiciary is an integrated constitutional mandated pillar of government in South Africa. And its independence is crucial for the proper functioning and execution of its mandate. It is within this context, Chairperson, that the NFP supports this budget. Inasmuch as we welcome the budget allocation, we share in the concern of the Portfolio Committee regarding the impact of the present funding constraints on the ability of the Office of the Chief Justice to deliver on its mandate. Particularly worrying is that the Office of the Chief Justice is unable to fill any new post in order to increase its much needed capacity to support the court. This situation is untenable, and it strikes at the heart of the mandate of the office, and it will have the effect of eroding our democracy in the long term if left unchecked. The NFP is also in agreement with the observations of the committee that our court must do more to promote all 11 of our official languages in the dispensing of justice. We understand the rationale behind the decision to use English only as a language of record, but it will be a travesty of justice in South African citizens, where if South African citizens were denied their right to having their matters adjudicated upon in a language which they understand and which is protected by our own constitution. Finally, we support the recommendations as well of the committee that additional funds be made available for the Office of the Chief Justice to ensure that our judiciary receives the administrative and infrastructure support which is necessary. It is a crying shame that entities such as SAA and SABC can record massive financial losses, which are often twice or triple the amount of the entire budget of the Office of the Chief Justice, but are then bailed out by taxpayers' money. Yet we allow our judiciary to flounder because of the lack of money. Somehow we need to get our priorities right and put our money to work in the institutions and department where democracy will be best served. The NFP supports this budget.
The next speaker is the Honourable Deputy Minister of Justice and Correctional Services, responsible for justice and constitutional development.
Thanks, House Chairperson, Honourable Minister, Honourable Members, and guests in the gallery. Let me too add my congratulations to our esteemed Chief Justice on his election as President of the Conference of Constitutional Jurisdictions of Africa. The CCJA promotes universal values and principles of law, democracy, and human rights across constitutional jurisdictions within Africa. These issues, law, democracy, and human rights, are values central to a constitutional democracy such as ours. Also central to a constitutional democracy is the doctrine of the separation of powers, which others have spoken about, a doctrine which aims to limit excessive government power by dividing it among the various branches of government, the legislative, the executive, and the judiciary, with various checks and balances to prevent any one branch from exercising too much power. There have been numerous cases before our Constitutional Court involving the separation of powers, a doctrine mentioned as early as the first certification judgment. But I think Judge Phineas Mojapelo perhaps said it best when he wrote in 2013, "In a constitutional dispensation, the doctrine of separation of powers is not fixed or rigid." He went on to say, "The courts are duty-bound to develop a distinctly South African model of separation of powers, one that fits the particular system of government provided for in the Constitution and that reflects a delicate balancing informed both by South Africa's history and its new dispensation between the need on the one hand to control government by separating powers and enforcing checks and balances, and on the other to avoid diffusing power so completely that the government is unable to take timely measures in the public interest." There's been a significant amount of discussion and debate as to what judicial overreach is and isn't. Some will argue that the courts is performing its duty as the custodian of the Constitution, while others will say that it's judicial overreach with the judiciary entering the domain of the executive. Law experts themselves are divided in their opinions as to where to draw the line on judicial overreach. But whichever way one argues it, and whether or not one agrees with the judgments or not, our courts have proved themselves to be independent. A media report published in April this year reads, and I quote, "This phenomenon of judicial overreach has become endemic only because the governing apparatus in this country has proved itself to be manifestly incompetent over many years. This compelled the citizens to seek relief from the judiciary. In some cases, the checks and balances framework worked. In the long run, however, it motivated the judiciary to inevitably carve out territorial supremacy at the cost of the executive," and close quotes. Another recent media headline reads, and I quote, "Judicial overreach should not be met with executive overreach." Now, House Chairperson, one might very well think that these are South African media reports, and I notice some of the members of the DA seem to quite like the first one, but they're not. The first is from a newspaper in India, and the second one is from the Washington Examiner in the United States. So the point really is this: the debate around judicial overreach is an international phenomenon. It is something we find in developed countries and also in developing countries. It's not a uniquely South African question. It's not the first time that the issue of judicial overreach is raised and fiercely debated, nor will it be the last. Nor is it a clear-cut issue either way. As a developing constitutional democracy, it's natural and normal that we will grapple with these issues, particularly, as Judge Mojapelo wrote, "The doctrine is not fixed or rigid." There are no easy answers, yet there are some points that we need to consider going forward. First, judges must bear in mind that they're invested with great political power. They're permitted to override measures enacted by the legislature and the executive, measures that the legislature and executive regard as constant with the Constitution. Secondly, judicial discretion often competes with legislative discretion and executive discretion. It is thus obvious that tensions will occur. Thirdly, the Constitutional Court, to its credit, has endorsed the principle of self-restraint on a number of occasions. Fourth, at the same time, government has accepted and complied with court judgments, particularly in respect of socio-economic rights, which is the area in which judicial activism mostly takes place. And we can cite many examples of this. Socio-economic rights, the TAC case on the provision of antiretrovirals, Fourie case on the same-sex marriages, the case on the withdrawal of the ICC, and the Causa case when government was ordered to make social grants available to foreign nationals. As President Zuma said at the United Nations, and I quote, "Perhaps nothing reflects adherence to the rule of law like the judicial settlement of disputes." Now, we may not always agree with the outcome of each and every case, just like every party who has ever lost a case or had an order not in its favor. We may not always agree, but it cannot be said that the ANC government has undermined the courts or undermined the rule of law. Speaker or Chairperson, transformation of the judiciary is not for us a numbers game. It is a matter of vital importance for the legitimacy of our constitutional order. Transformation is linked to independence, as former Chief Justice Chaskelson pointed out when opening the 2003 National Judges Symposium, and he said, "The impartiality of the judiciary is more likely to be respected by the public if it is seen to be drawn from all sectors of our community than will be the case if it is drawn from one race and one gender." The issue of transformation of the judiciary is also often an emotive one, and one which has been at the heart of ANC policy for decades. And yes, we believe that aspirant judges must be progressive. At its 2002 National Conference in Stellenbosch, the ANC resolved to expedite the transformation of the judiciary to create a more representative, competent, sensitive, humane, and responsive judiciary. This was echoed in the 2013 Mangaung Conference resolutions, which state that, and I quote, there should be holistic criteria for eligibility to judicial appointment, which include, amongst others, social activism. A transformed bench would be the result of a transformed legal profession. Yet we know that briefing patterns and the allocation of types of legal work to, in particular, black and female counsel remain problematic. It is thus encouraging that the judiciary itself is doing its bit to ensure transformation in the allocation of work, with the Gauteng High Court Judge President Dunstan Mlambo recently directing court staff to record the race and gender of every advocate appearing in motion court in the High Court in Pretoria. And by collecting the data on briefing patterns, we will now be able to determine which counsel dominate different areas of litigation. This then becomes useful to assist transformation in the legal profession. We have a policy for the State Attorney that 76% of the value of briefs from the State Attorney should go to previously disadvantaged individuals. In the 2015-16 financial year, the value of briefs going to previously disadvantaged individuals was 4% over that at 80%. And details of the briefs given by the State Attorney are now available on the Department of Justice's website. Honourable members, the recent Judicial Service Commission interviews have raised issues of concern and in particular laid bare existing racial and seniority divisions within the Supreme Court of Appeal. As one candidate candidly remarked, and I quote, "White judges sit at one end of the table in the tea room and black judges at the other." Now, 4 of the candidates were from the SCA, and hence the focus on the SCA, but the real question should be, what about other courts? Is it just the SCA, or are there other courts where these divisions are also apparent? And if so, what is the judiciary as a whole doing to address it? Another area of some concern is the result of the Victims of Crime Survey for 2015-16. This survey is a countrywide household-based survey which, amongst others, focuses on people's views regarding access to and effectiveness of the criminal justice system. And it's a matter of concern that the survey shows declining trends in levels of satisfaction with the courts. The findings show a decline in the percentage of households who are satisfied with the way the courts are dealing with the perpetrators of crime in all provinces except Limpopo. The highest level of satisfaction with the courts was observed in Limpopo, which was 73%, and the Western Cape displayed the lowest levels of satisfaction with the courts at 32%. So in this regard, it would be important to engage the judiciary on measures that we, the department, and the judiciary together, along with other role players, could implement to raise confidence and trust amongst members of the public in our court. It's also something that the National Efficiency Enhancement Committee and the Provincial Efficiency Enhancement Committees, which were established by the Chief Justice, could investigate further. I also want to stress the importance of our continuing engagement with the judiciary, especially the Chief Magistrates Forum and the Regional Court Presidents Forum, so that we can improve access to justice and address any blockages or shortcoming in relation to the efficiency of our courts. Magistrates' courts continue to be the first port of call for access to justice for most people, with 740 courthouses countrywide, of which 154 are periodical courts and 180 are branch courts. For a court to render a service, it must be supported by officials and other role players who are committed to serve the public and the cause of justice, in particular the needs of the poor and most vulnerable. Honourable members, the budget vote also presents an opportunity for us to report back on progress made since last year's budget vote debates. With regard to the current governance arrangements in the lower courts, a joint task team made up of magistrates and officials have considered draft regulations on a number of issues. These regulations were submitted to the Magistrates Commission for consideration, and we are awaiting their inputs, which they will hopefully give at their meeting at the end of next week. Members would recall that we also committed the Department of Justice to develop a draft lower courts bill, which is intended to rationalize and transform the legislative framework of the lower courts in line with the Constitution by overhauling the Magistrates Court Act of 1944 and transforming the lower courts in line with the Superior Courts Act of 2013. The draft framework on the bill was discussed with representatives from the magistracy in January this year, and we've since received their comments. The further work of the task team and the drafting of the lower courts bill was unfortunately delayed due to unforeseen human resources and budget constraints, but we are now once again on track and in a position to take the process forward. During this past financial year, the Minister of Justice and Correctional Services appointed 4 chief magistrates, 25 regional magistrates, and 48 senior magistrates to vacant positions, and the Magistrates Commission will soon commence with interviews for a further 214 posts of magistrates. Just in the little time that I've got, obviously the issue of institutional arrangements need to be debated, but the questions are issues such as accountability. Who will account to Parliament for expenditure if there's complete independence? Should it be the Chief Justice, him or herself? Is that appropriate? The Auditor General, for example, accounts to Parliament, but is it appropriate for the head of the Judiciary to account? Is it appropriate that it is the head of the department, which is then different to the Public Finance Management Act? But currently, the Office of the Chief Justice is a separate department with a separate budget, which they administer. It's not administered by the Department of Justice, and they go to Treasury themselves to motivate for their funds. So I just wanted to clarify the existing situation. The Minister of Justice remains the person, as the Constitution provides, a member of Cabinet responsible for the administration of justice. He remains, in terms of the PFMA, the executive authority. But there is engagement with the Office of the Chief Justice himself and the heads of court. So there is a bit of a distance between the OCJ and its administration and the minister, more so than with the Department of Justice. But it is still a government department as it stands at the moment. But we will continue to assist the Office of the Chief Justice as part of its constitutional mandate to ensure the independence, impartiality, dignity, accessibility, and effectiveness of our courts. One of the new Sustainable Development Goals calls upon all countries to promote the rule of law and to ensure equal access to justice for all. It's a goal that we are unrelentingly committed to. Also, just to raise the question of language, as that was raised by some of the speakers, it is something that we need to move faster on. There was a pilot project in the Northwest where the court could be entirely conducted in the main language in the area, which was Setswana, but there were some issues which arose relating to the question of the translations of the record if there needed to be appeals or reviews. But it is definitely something that we need to move forward on. I think the suggestion the Portfolio Committee made that each at law schools, in the past we had to learn Latin and Afrikaans, that people should learn at least one indigenous language. I think that is very important. So thank you to those who supported this budget. Thank you.
Thank you, Honourable Deputy Minister. The next speaker is the Honourable Maila.
Honorable House Chairperson, Honorable Minister, Deputy Minister, Honorable Members, the Secretary General, esteemed guests. The Office of the Chief Justice has an important role to play in the transformation of the judiciary. Transformation in the South African context extends beyond demographics. It entails alignment to the Constitution. A transformed judiciary, according to former Chief Justice Ismail Mahomet, is one in which racist, authoritarian, insular, and repressive tendencies have been done away with.
Doing away with such tendencies will not be an incident, but it will be a process. In the 52nd National Conference on the issue of transformation of the judiciary, the ANC resolved that judicial training and skills development of our judiciary is non-negotiable and must be vigorously pursued. Appropriate mechanisms must be urgently established to pursue the priority of establishing an adequate pool of judicial officers who are steeped in and reflect the progressive values of our Constitution. In our relentless pursuit of the transformation agenda, Parliament passed the South African Judicial Education Institute Act, thus enabling the establishment of the South African Judicial Education Institute, the SAJE. Many judicial officers received their legal training before the advent of the new constitution. This creates a need for further training on constitutional jurisprudence. The training of magistrates and judges in understanding the Constitution, values, aspirations, and traditions of all the people is an important element of access to justice and observance of the rule of law. The SAJE was established as a national education and training institution to enhance the judicial accountability and the transformation of the judiciary. It was established to further educate and train aspiring and newly appointed judicial officers with the purpose of advancing their capacity and skills. The Institute also serves as a platform for continuous education and development for judicial officers. In reaffirming our commitment to the independence of the judiciary, the SAJE is primarily directed and controlled by the judiciary. The Institute is governed by a council chaired by the Chief Justice. To enable the SAJE to make a meaningful contribution to the transformation agenda, we should adhere to the constitutional prescripts guiding the appointment of judicial officers. Section 174, subsection 1 provides that only a fit and proper person may be appointed as a judicial officer. And Section 174, subsection 2 makes a provision for the need for the judiciary to reflect broadly the racial and gender composition of the country, which should be considered when appointing judicial officers. While great strides have been made by the Department of Justice in pursuing inclusivity, there is still a long way to go. In 1994, there was only one female judge. According to the statistics on the number of permanent judges in the country as of 30 April 2015 were as follows. There were 239 permanent judges. Of these judges, 104 were African, 24 colored, 24 Indian, 87 white, and 81 were female, and 158 were male. According to a report by the Commission on Gender Equality titled Lack of Gender Representation in the Judiciary, gender transformation is still slow. The report maintains that the lack of gender transformation is not only applicable and post, but is also reflected in the appointment of acting judges. According to the constitutional law expert, Pierre Divorce, in order to address gender transformation in the judiciary, several factors need to be considered. These include transforming the institutional culture of the bar and the judiciary, which is dominated by white males, addressing sexist and racist perceptions, availing opportunities for exposure to different types of work for those who were previously disadvantaged, addressing the underbriefing of black and female advocates, addressing lack of training and mentoring for female judicial officers, and addressing lack of practical experience for women as acting judges. The reality is that judicial officers are chosen from a pool of lawyers, and there are far fewer female than male advocates from the pool. And this leads to a limitation on the number of female candidates. The SAJE is better placed to address this problem. The SAJE is a tool for opening doors and an institution supporting democracy. The ANC supports this budget. Now, we have observed that the EFF has been rejecting all the budget votes, but only approving the vote for this particular vote. We don't know what they want to achieve by this. But unfortunately, the judiciary cannot be swayed and the judiciary cannot be bought. On the other hand, the DA has built a highway to court. The devil's advocate takes every matter to court. It has lost its credibility as a political party. It is about time that the DA should capitulate and turn itself into an NGO. The deep divisions between the black caucus and the white caucus is rendering the DA useless. It can't deal with racism within its structures, and it is found wanting to deal with those who are pro-colonialism. I've been checking why the AFF could be in cahoots with the DA. And I found that there are only 3 points of convergence. One is that both of them have a passionate hatred of President Jacob Zuma. 2 is that both of them are funded from London. 3 is that both of them get instructions from London. The only irony is that the instructions that they get from London are not compatible.
Order.
My time.
No. Oh, point of order.
House Chair. Well, I think a member is making a...
No, honorable member. What are you rising upon? Is it a point of order?
On a point of order.
On what rule? Yes, it is in the rules. You've got to tell me the rule on which you are rising. Which rule?
Rule 92.
Okay.
Now, the member makes a frivolous allegation, unsubstantiated, that the EFF is funded from London. So I would like the member to withdraw or to bring forth a substantive motion. A member to withdraw or to bring forth a substantive motion.
Honorable member, unfortunately your point of order is not sustained. It's a point of argument.
Okay. The irony is that the instructions that they get from London are not compatible. The DA goes to London, they are instructed.
On a point of order.
Okay, honorable member, you may
on Rule
come in.
92.
Okay, Rule 92, you may proceed.
House Chairperson, we understand that your family is also on the race of presidency.
Yes.
But in this house, you must treat us equally. We understand that your husband also wants to stand as a president of the ANC. Don't favor the ANC in this house. The member is coming up with a point there, which we are asking you to rule on it. Whether you are saying our point of order is not sustained.
Honorable member.
But what
point of order, Chair. Honorable member.
Point of order, Chair.
Your point of order has no relevance with the debate, but also it is not sustainable. Honorable member, there's another point of order.
Say don't allow the debate because we was debating. Oh, Papa Luna.
Also, honorable member, your point of order is not sustained. Honorable member, may you proceed.
The DA gets an instruction. Go and embrace Mandela. They come here, denounce their de Klerk, denounce their Malan, denounce their Botha, and say Mandela is theirs. The EFF goes to London. They get an instruction. Go to South Africa and denounce Mandela. And shamefully, they do just that. Thank you very much.
Thank you, honorable member Maila. I will now call upon honorable member CP Mulder.
Yes. Thank you, honorable chairperson. The previous speaker made an interesting speech until he started to venture into politics. Then it became rather irrelevant. Speaker, chairperson, the fact of the matter is that we've got a constitutional state. And the Constitution is very clear in the founding provision of Section 1, which is that entrenched provision of the Constitution, says that the values we are built on our Constitution basically supremacy of the Constitution and the rule of law. And then Section 2 of the Constitution clearly states that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid. And that is where the courts come in. Nou is dit so dat die trias politica leerstuk waarna vandag reeds verwys is, maak voorsiening vir die 3 arms van die staat, naamlik die regsprekende, die wetgewende en die uitvoerende gesag. Hulle is veronderstel om te funksioneer in 'n gesamentlike kombinasie, want een kan nie sonder die ander in klaarkom nie. Maar ek kan nie verseker as daar vandag 'n meningspeiling gedoen moet word daar buitekant. En ek dink daar is al gedoen onder die publiek, onder die kiesers van Suid-Afrika, om te sê hoeveel vertroue het julle in die wetgewende gesag? Hoeveel vertroue het julle in die uitvoerende gesag, die kabinet, die executive? Hoeveel vertroue het julle in die regsprekende gesag? Then the answers will be very interesting. We'll find that the public out there do have confidence in the judicial authority of South Africa, in the courts. Hulle het baie vertroue daarin. Hulle het feitlik geen vertroue in die wetgewende gesag, dis ons wat hier werk nie. En dat beslis nog minder vertroue in die uitvoerende gesag. En die rede daarvoor is baie ooglopend. Daar word gesê, en die ANC probeer dit wegsteek vandag deur te sê, hulle respekteer die howe, en hulle respekteer die uitsprake van die howe ensovoorts. Dit is net op na die oppervlakte. The truth is the opposite. Die agbare adjunkminister van Justisie het verwys na hoe die regerende party die uitsprake van die howe respekteer. En wat het geword in die Al-Bashir saak? ANC went out of their way to undermine that. Daar is vandag gesê dat die ANC en die ministers hef baie groot waarde aan die uitsprake van die howe en hulle voer uit daardie uitsprake. Maar dis nie die geval nie. Daarom kry ons 'n SASSA gemors wat die minister nie gedoen het wat die regering wat die howe hulle basies gelas het nie. So die feit van die saak is, daar is tans die politieke geveg, the political debate and the fight has been moved away to the courts. And obviously the courts don't want to do that. It's not the task of the courts to intervene and to overreach. But why did they have to do that? History will show that it goes back to a very large extent to what happened in the Nkandla affair. Because then it was necessary for the court, can you imagine, the courts to come around and to say, the legislature failed. The executive failed. And the public took note of that. We did not do our job. And it's not, and then you come along and you say, well, Parliament didn't do its job. No, it is not Parliament that did not do its job. It was the ruling party who did not do its job, who used and misused its majority to bring Parliament and the legislative arm into disrepute.
Honourable Member, round up.
Die feit van die saak, agbare voorsitter, is dat al is ons ongelukkig oor baie dinge wat hierdie situasie betref, is dit nie goed om die kantoor van die hoofregter te straf daaroor nie. Ek dink mense moet die debat ondersteun, die begroting ondersteun en dit moontlik maak om aan te gaan met daardie goeie werk. Die probleem lê by die uitvoerende gesag en by die wetgewende gesag in hierdie meerderheid. Baie dankie.
Thank you, Honourable Melder. I will now call upon Honourable D. Carter.
Thank you, House Chairperson. Chair, in what at face value seemed like a light-hearted exchange in the Constitutional Court hearing on the vote of no confidence matter, an advocate in presenting his argument made the statement that, and I quote, "Judges are human beings, and in order for them to give unpopular yet correct decisions in law, they need security. And that is why the Constitution guarantees judicial independence by providing security of tenure, so that sitting as judges, you are enabled to take decisions you would otherwise not make had you otherwise not had the protection." At this point, Chief Justice interjected and, in what seemed like in a light-hearted manner, said, and I quote, "Well, no. That presupposes that the only danger out there is being removed from your position." Close quote. And then, more chillingly, the Chief Justice continued, "There are more serious dangers, believe you me." The doctrine of a separation of powers in a democracy is premised on the need to ensure that the powers of a state are divided between the executive, the legislature, and the judiciary, in order to prevent the abuse of power. One of the primary foundations that anchors our democratic state is the supremacy of our Constitution and the rule of law, and a primary function of our judiciary is to protect both. Mr. Zuma, his executive, and the ANC is unwilling to accept that conduct that is inconsistent with the Constitution is invalid, and that the obligation imposed by the Constitution must be fulfilled. The blatant disregard for and non-implementation of orders of the court and the slurs against the judiciary by the executive are simply not responsible or acceptable in a constitutional democracy. The executive have a constitutional obligation to assist and protect and ensure the dignity of the courts, not attack it. Utterances and threats against the judiciary, unwarranted statements of judicial overreach and claims of judicial interference in the powers and functions of the executive and the legislature, the stirring up of public sentiment against the judiciary by the ANC, as we've witnessed in the ANC march to the High Court in Durban this week, attacks the very foundation upon which our democracy has been built. It's not the judiciary at fault. The crisis that we currently face in South Africa as a whole, and that threatens our very democracy and the future of generations to come, relates to the gross abuse of power by the President and his executive, conduct by both the executive and the legislature that is inconsistent with the Constitution, and obligations imposed by the Constitution on the executive and legislature that are not being fulfilled, not the judiciary. To date, we still don't know who was behind the worrying break-in and theft of computers from the Office of the Chief Justice. But what is clear is that the judiciary faces intimidation. They are being threatened and to face dangers. COPE stands in solidarity with the Office of the Chief Justice when it recently stated that the judiciary, and I quote, will continue to be fearless in its approach to promote the rule of law and safeguard its independence. We need to protect our judiciary from a rogue and abusive executive, a non-compliant legislature, and a captured, corrupted ANC.
Honourable Member,
intent on
round
clinging
up.
on to powers at all costs. COPE fully supports this vote. I thank you.
Thank you, Honourable Member Carter. I will now call upon Honourable Member S.N. Swart.
Thank you, Chairperson. Now, we know that the Office of the Chief Justice was proclaimed as a national department in 2010, and this was envisaged as the first phase towards an independent, judiciary-led court administration in order to fully realize institutional independence in line with the Constitution and the Superior Courts Act of 2013. And that, regrettably, is still fully to be implemented. And so we from the ACDP side look forward to the full implementation to ensure that institutional independence. But now we had a very interesting discussion around the issue of judicial overreach. And of course, a lot of people see that against the background of the burglary at the office of the CJ. I was at the office last year when the Portfolio Committee met with the judiciary and security appeared to be tight. And we understand that issue is still being investigated. We are not aware of whether there were CCTV cameras. I asked the question in the Portfolio Committee, but understand that there are issues around the investigation, but it is concerning. And the question arises whether this was just a criminal act or something more deeper and sinister. And we need to see this against the background of increased criticism of the judiciary, as pointed out by other members. It is disgraceful that President Zuma himself urged traditional leaders not to trust the courts of law. This less than 2 weeks after the scathing Nkandla judgment against both us and us being Parliament and the Executive. And this caused the Chief Justice to call that unprecedented meeting with the President and to allay those concerns. Now, that statement by President Zuma is not debating judicial overreach. In fact, it is contempt of court. So when we also, the Deputy Minister, John Jeffrey, discussed judicial overreach, and we see the Sassa judgment, where it is very clearly pointed out the way the court approaches it. And as Honourable Mulder said, they don't want to get involved in these political issues. The litigants come before them. The court there said, in a constitutional democracy like ours, it is inevitable that at times tension will arise between the different arms of government when a potential intrusion into the domain of another is at stake. It is at times like these that courts tread cautiously to preserve the comity between the judicial branch of government and other branches of government. The court said in that case, it is important to note that in this particular role, at this particular time, is not one of the court's choosing. The sole reason for this litigation is the failure of SASSA and the minister to keep their promise to this court and the people of South Africa. And that, colleagues, is the heart of the matter. If the executive does not perform its function, and if we as Parliament do not exercise our oversight function, the courts are obliged to step in and to intervene and uphold the rule of law. So from our side, from the ACDP side, we regret that the Office of the Chief Justice does not have sufficient funding. It is disgraceful that we're opening a brand new court in Mpumalanga Court. My dear friend, to be appointed Judge President Francis Lachodi, how's he going to set up his court without staff? We need to ensure
Honourable
that
Member, round up.
Parliament gives that staff in to ensure that court is properly exercised so that they can exercise their judicial functions correctly and uphold the rule of law. Thank you very much.
Thank you, Honourable Member Swart. I will now call upon Honourable Member B.T. Bongo.
Thank you very much, House Chair. Honorable Minister, Honorable Deputy Ministers present, Members of Parliament, fellow South Africans, Secretary of the OCJ, President Tambo, the President of the ANC, as he then was, had the following to declare even before the ANC took over government in 1994, and I quote, "No political democracy can survive and flourish if the majority of its people remain in poverty, without land, without their basic needs being met, and without tangible prospect of a better life. Attack poverty and deprivation will therefore be the first priority of a democratic government." This was also, unquote, it was also further in 1994 in a volume 5 of the ANC documents dealt with. The mandate of the Office of the Chief Justice is to support the Chief Justice in the execution of the administrative and judicial powers, and as a head of the Judiciary and the head of the Constitutional Court. These functions include, inter alia, to develop court administration policy, norms and standards. OCJ supported the Judiciary, and it is part of a very important document which was brought by the African National Congress, which is the National Development Plan. Chapter 13 and Chapter 14 is supported by this budget vote that we're dealing with. During 2016-17 financial year, the OCJ came to the committee and briefed the committee about the performance. As the committee was raised, among other issues, with the Judiciary, the dwindling hours of the court sittings which are happening, which are depriving the proper administration of justice. We've also discussed issues that relate to some poor governance, issues that relate to some minor corruption that are reported by other sectors of society. We're proud and we're happy that the Chief Justice and the office has raised around the issue of the benefits of judges. That the benefits in terms of the act that was enacted before 1994, in 1994, gave judges a lot of benefits as above these other state organs, which the executive and the legislature. But the Chief Justice himself has taken it upon himself to reduce some of these benefits, and that is very positive to show patriotism from the side of the Chief Justice himself. The separation of powers consists of basic principles of res politica, which simply require a formal distinction which must be made between the legislature, the executive, and the judiciary as the component of the state. It will be wrong for a lot of people today to mislead the people of this country when they have an issue with a member of the executive, of a legislature, or the judiciary, to start to say that is the state of the capture, because the state, in its totality, it is composed of the legislature here, it is composed of the executive and the judiciary. That makes all of us combined. That is why we must coexist, all of us. Guiding principle of a constitutional supremacy seeks that we need to incorporate this principle. This principle requires that judges, in taking their decision, they must be very conscious in the exercise of power. There are vital limits on the judicial authority itself. This was demonstrated in the case of Davis J. Davis J. in the case of Mazibuko versus Sisulu, and another before the Cape High Court. The judges, Judge Davis, they had to warn, and I quote, an overreach of the power of judges, their intention into issues which are beyond their competence and intent jurisdiction, or which beyond deliberately or carefully constructed legally, as to ensure that the other arms of states deal with matters that can result in jeopardy for the constitutional democracy that we have in South Africa. Honorable Swart comes here, speaks about a person as if he himself respects the Constitution or his party. The party of Honorable Swart does not respect this Constitution. Section 9 of the Constitution, which they don't respect, they don't even deal with, it says, I quote, it states that the state may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, or birth. Honorable Swart's party does not want same-sex marriages, which is provided for in this particular constitution. But today they want to grandstand about the issues of the constitution, how it must be respected by the ruling party. I find that to be disingenuous. Now, as part of what the opposition wants to do, they are saying
Order.
They are going to court. I was watching television. They are saying, we must come here, members of the ANC must vote with their conscience. But what we have seen demonstrated here, the DA is supporting this budget vote. The EFF does not support. So if that matter of motion of confidence is brought in this house, they must know that some of their members who agree with us are going to vote with us. So this academic exercise of going to court, I think it's just being disingenuous.
A point of order. I recognize the honorable member.
Chair, we actually do support this budget vote. This guy is distorting us. We did say we are supporting it.
The DA does not support. You support. The
Honorable members.
You must get your facts right, because if that is your
Honorable
closing
member,
argument,
order.
you are a failed advocate.
Order, honorable member. You are rising on, I think you are arguing. It's not a point of order.
Honorable Chair, on a point of order. On a point of order.
Order.
Yeah, the
Yes.
previous speaker has just referred to an honorable member of parliament as this guy. It is against Rule 84 of this house. Can she please address him properly? Thank you.
Honorable member Tlangwini, did you refer to honorable member as this guy?
Well, Honorable Bongo is the man, but Honorable Bongo.
So you have to withdraw the earlier assertion on.
I withdraw with Guy, but
Thank you very much. You may take your
seat.
seat. Thank you.
Woman Bongo.
No, thank you, Chair. What I was saying was that in this budget vote, the DA does not support, the EFF support. It shows the disparity that will happen if we will vote for a motion of no confidence here in Parliament. Because those in the EFF who don't agree with the decision to match with the DA in Tshwane and Joburg are going to vote with us this side. So the numbers are going to grow this side than what you are expecting. So this academic exercise of going to court and seek some orders that will want the court to want a secret ballot here, I think they are just out of order.
House
Now-
Chair, on a point of order.
Yes, you are recognized.
House Chair, we made a proposal in the past that, in fact, we need to bring breathalyzers in this house.
Is that,
This
honorable
man
member,
seems
that's
to
not
be
a point
very
of
much
order.
confused. It's very much
Honorable member,
confused. We're bringing that proposal
may you
again that
please
we
take
need
your
to bring
seat? This is
breathalyzers.
not a point of order. Thank you. You may proceed, Honorable Member Bongo.
If you speak again, I'll expose you.
Honorable Member.
Now, thank you, Chairperson. So what I was saying that this back door of wanting to remove the
Order.
president, which was
On a
elected by
point
the
of order,
people,
Chairperson.
is not acceptable.
On a point
Okay,
of order,
Honorable
Chairperson.
Member, I recognize you.
Honorable Chairperson, you and the table staff have seen what F. Bongo did. None of you want to correct him. So I want the table staff to finally do their job. This guy in front there of the table staff is continuing not doing his work. So if he's not going to do his work, I will lay a formal complaint. Let Bongo withdraw what he said about threatening a person and speaking directly to a person. Expose. We'll start exposing. Expose. Expose.
Honorable
Did you take
member.
to your wife the cows that you are having?
Honorable
what happened here in
member.
Parliament? Did you pay the cows? Let's expose.
Honorable Member, again you have referred to Honorable Member as this guy, which is unparliamentary. So I'm going to request the Honorable Member to withdraw that word again. And then Honorable Member Bongo, may you please focus on your speech.
Thank you, Honorable Chairperson. The preamble of the Constitution of South Africa has the following provision to say.
House Chair,
Yes, Honorable Member, I recognize you.
I regret to say it's like you are losing control over the House. Can you please instruct Honorable Bongo to withdraw the remarks he made and a direct threat against our member before even he can attempt to proceed.
Okay, Honorable Member, I have the table staff here. I really would like to postpone the ruling on this one because I'm trying, the table staff must assist us with anything that is unparliamentary. Yes, the table staff must refer to the tape and then advise me. It is allowed in the rules. I didn't say I want rule. I said I would like to postpone the ruling until I have my facts right. Honorable members, can you please conduct yourself in a manner that will still uphold the dignity of this House? Honorable member, please don't be disorderly. Can we continue to uphold the dignity and the decorum of this House?
Thank you very much, Chairperson.
You may proceed.
Of the Constitution lay the foundation for a democratic and an open society in which government must be based on the will of the people and every citizen is protected by the law. So what I was saying that this backdoor of wanting to remove a government of the people by these opposition parties, it's unacceptable and regrettable, and it will not happen in this country. Lastly, Chairperson, the issue I want to raise, which was raised by the Chairperson of the committee sharply, is the issue which we want the department to take very serious about the indigenous use, the use of the indigenous languages in courts. We have been reported, Chair, that in Mankweng, in Polokwane, there was a case where a magistrate who was white and all other people, the interpreter, the lawyer, and so on, were black. There was an issue there where a person came there, he assaulted his wife. After the assault of his wife, what happened was he pleaded guilty. And those who are lawyers know if you plead guilty, then you must give a plea explanation. In giving a plea explanation, he said, I'm pleading guilty. They say, why? He said, untimile mapai in a traditional language.
And the issue was, why didn't you buy your own blankets? And he was sentenced on those bases that he was supposed to buy. So the issue raised by the chairperson about the use of indigenous languages in our courts is an issue that we must elevate. We want the budget vote next time to take good care of this particular issue so that we use our indigenous languages so that in areas where people speak a particular language, they can conduct
Honorable Member, round up.
They can conduct all the proceedings in those languages so that access to justice is promoted. The ANC support this budget vote. Thank you very much once more.
Thank you, Honorable Member Bongo. I will now call upon Honorable Member W. Horn.
Thank you, Chair. The unenviable and thankless but yet paramount task of our judiciary was described with great clarity in the 2006 judgment of our Constitutional Court in the case of Affordable Medicines Trust versus Minister of Health, in which the court held the following. The exercise of public power must therefore comply with the Constitution, which is the supreme law, and with the doctrine of legality. It entails that both the legislature and the executive are constrained in the principle that they may exercise no power and perform no function beyond that conferred on them by law. Chair, this uncomfortable reality is of course at the root of all criticism from the ANC against the judiciary. An ANC which, despite the protestations here today, more and more regrets ever insisting on installing constitutional supremacy in our country, and who wants to go back to the system we had during apartheid of parliamentary supremacy. And if you don't believe me, go listen to the recordings of our portfolio committee where some ANC members have expressly stated this. Through you, Chair, Honourable Minister, you have today referred to this task of the judiciary to evaluate the exercise of public power as vexed. Chairperson, my dictionary tells me that vexed, apart from meaning much debated, also means problematic, annoying, frustrating, and irritating. Therefore, Honourable Minister, at best, you displayed a very bad choice of words. But the Deputy President, who was present during your speech, as one of the main architects of our Constitution, will be able to assure you that the decision to entrust the judiciary with the authority of being the ultimate arbiter of whether the legislature and the executive exercise their power in a manner consistent with the Constitution was done in a deliberate manner to exactly prevent the type of abuse this country saw during apartheid. The Deputy Minister's argument that we must be okay with criticism calling the manner in which the judiciary deals with these issues judicial overreach because it happens all over the world sounds a bit like somebody who was caught by traffic officials speeding, arguing in court that they must not be fined because everybody's doing it. In all seriousness, Chair, this specific provision in our Constitution was actually part of the never again provisions in the Constitution. And it is not befitting for a Minister of Justice who must protect the Constitution to describe this authority as vexed. Furthermore, the Minister, as a constitutional jurist himself, must tell us why we must believe him and the Deputy Minister, rather than the ANC rank and file, who again on Monday took this discussion to an all-time low when the ANC in KZN not only said that the courts want to govern, but accused our courts of trying to rob people of their rights. Now, Chair, also on Monday, and as has been alluded to by the Honourable Carter, prior to the hearing of the matter in the Constitutional Court regarding the application of the UDM for a secret ballot in the no-confidence debate, the Chief Justice saw it necessary to issue a statement on this issue. In this, he stated that, and I quote, "The South African judiciary reaffirms its commitment to the principles of independence, impartiality, dignity, accessibility, and effectiveness of our courts. The courts, as provided for in our Constitution, exist to promote the rule of law and to uphold the supreme law of the country. the Constitution. The South African judiciary has been and will continue to be fearless in its approach to promote the rule of law and safeguard its own independence. And then, as referred to already, during the hearing, Chief Justice Mogoeng made a startling yet coded revelation that members of the judiciary may face unspecified threats. In the throwaway comment during the hearing, Justice Mogoeng suggested judges are facing dangers much more serious than the risk of losing their jobs for taking unpopular decisions. While he gave no specifics of the dangers he was alluding to, every single South African who holds dear our constitutional democracy should be alarmed by this statement. It must be extremely worrying that our judiciary, or maybe those close to them, are in all probability under threat of physical harm. Chair, add to this the specific content of this budget for the OCJ, proposed here today, in which, apart from not even enabling the full capacitization of the Mpumalanga High Court or implementation of the Superior Courts Act, also does not allow for either the upgrading of security at the Office of the Chief Justice or for the personal security of judges. Aspects also criticized here today by the Honorable Motshega, who, having freed himself now from the shackles of having to defend the President all the time, has been blessed in this debate with a newfound clarity. Therefore, Chair, the question must be asked, why should we not brand this budget, and specifically what it lacks, as part of a campaign to intimidate our judiciary into a state of deference to the executive and the legislature? An answer to this question would be welcome.
Thank you, Honorable Member Horn. I will now call upon Honorable Member MCC Pilane Majake.
Honorable House Chairperson, members of the executive, judges present here today, Secretary General of the Office of the Chief Justice, honorable members and members of the public. Quite evidently, the whole issue of judiciary is a contentious one. As you could see, member after member coming to debate and the disagreements that are there. You see, the culture that has developed in South Africa is to keep on bickering and blaming. None of the members of the opposition who came here and were lamenting ever said, we think this could be the solution. We need to be solution-oriented. And for now, I need to remind you that to be saying a whole lot of things like parliamentary supremacy is what the ANC is looking for. I've never heard of anything that's talking about supremacy of the three arms of state. Constitutional democracy emphasizes equality. Now you're busy coming with all sorts of concepts that nobody understands where they come from. Other utterances is about corruption and captured ANC, judiciary being intimidated. The public does not have confidence in the legislature. And of course, the public won't have confidence in the legislature if members of the legislature are going to carry themselves the way we've seen some drama this afternoon by the member of the EFF. But this were utterances of Honorable Mulder, because it's our responsibility as members of parliament to carry ourselves in a way that continues to say to people we are representing here to say, yes, we've got this order in control. Judiciary overreach, like Deputy Minister Jeffries has actually put it forward, is something that continues to be interrogated in all countries. If you take, for example, a country like America, annually court judgments are actually assessed and evaluated by a group of experts. They're not just doing it for the sake of it. It's because they want to actually be sure that whatever they've got for Americans is fair. And Americans actually want to actually relate to it. So in South Africa today, when you talk about issues of this nature, what the opposition begins to say, look at you. Now you want to attack the judiciary. Nobody wants to attack the judiciary. Nobody wants to take the independence of the judiciary. But when South Africans pause and say, let's look at what is happening, don't make them feel bad. It's a new form of oppression in South Africa, of shutting people down. When people say something, you have a way of wanting to shut them down. And what the opposition continues to say, like I said it in the morning, you continue to patronize the judiciary, like you own the judiciary. The judiciary belongs to all South Africans. And the minute you start wanting to gain favor, that is corruption. Let's explain what corruption is to you today.
Order.
We continue also to realize that the DA, we've been pussyfooting, and that has got to do with what was earlier alluded to as racial segregation that is continuing to exist within the judiciary. You'll tell me that I'm against the judiciary when I'm talking about issues of this nature. It's matters that needs to be raised when there's a process of oversight. But then what is interesting is to look at how you're pussyfooting, the DA, around your own leader Helen Zille's matter, because you just realize that more and more of you are actually thinking like Helen Zille. The prosecutor is sitting here, Honorable Breitenbach. If you can actually tell us how far are you with the matter, to show how serious you take the matter. And what it actually says, it talks a lot about even what is happening in terms of your interpretation of how we relate to the judiciary because of the kind of stereotypes that you continue to carry. And those stereotypes that you carry will continue to go into how you view the leadership of South Africa today. And as long as you don't come to terms with it, it will of course become problematic. The budget, the summary of the budget for the 2017 MTEF for the Office of the Chief Justice.
Honourable Member, your time is now expired.
The ANC supports the vote.
I now call upon the Honourable Minister of Justice and Correctional Services to respond to the debate.
Chairperson, once again, thanks to honourable members who have contributed to this debate, and in particular, who have supported the budget allocation for the Office of the Chief Justice. Let me, at the risk of abusing the name of OR, also add to a list of words of wisdom that he has left behind during his days of struggle for freedom in this country. One quote that comes to mind, and I quote, he said, "The fight for freedom must go on until it is won, until our country is free and happy and peaceful as part of the community of men. We cannot rest," end quote. I'm quoting this for the simple reason that it has become a typical phenomenon in South African politics and public discourse to be diverted to the primary task at hand and to focus on our day-to-day political, social, and other prejudices which do not focus us on the central task of ensuring that the ultimate goal of transforming this society into one that is inclusive, that is non-racial, hopefully eventually non-partisan if that can be achieved, when it comes to dealing with issues of substance and importance to the well-being of our people, characterizes the public discourse and characterizes our approach even in relation to what has become typical of, say, opposition politics in South Africa, which have shifted from this House to the courts. And if you look at the kind of issues that are being taken up in constitutional litigation, you wonder whether the opposition really has the primary objective of transforming the lives of our people for the better at the heart of their political objectives, or whether it is all about trying to win political power in order to do the kind of things that we have seen, for example, with the DA taking over the Western Cape and seeking to resuscitate the very era that we seek to rid our society of, and that is the dark days of apartheid and colonialism, as so aptly articulated by their leader, Ms. Helen Zille, on numerous occasions in public statements, unrepentantly so. And I think going forward, we as the African National Congress must make sure that the noises, no matter how loud, do not derail us from the central objective of ensuring that we radically transform society in order to ensure that those that had been excluded hitherto from the economy, from the quality of life that others enjoyed over centuries, finally get to have a place in the sun as well. Let me say that the DA is a very interesting party. Mr. Horn here engaged in a debate earlier on when we were debating correctional services on this topic of judicial and executive overreach, whatever you call it, prematurely, in circumstances where nobody else had raised the issue. So you can already see that DA members are programmed to come and say certain things in the House, regardless of how relevant or irrelevant they may be, through his master's voice, as they say. Now, we are determined as the African National Government to ensure that in everything that we do, ultimately, the central task of ensuring that freedom that OR talks about is realized by our people in all its manifestations. Real economic freedom, not the kind that
Honourable
EFF
Minister, your
has in
time is
mind,
now expired.
of land grabs and so on, but one that is achieved through legitimate means. Thank you very much.
Honourable members, the outstanding ruling on the point of order raised earlier will be given in a later sitting. The table staff must first consult on the matter. That concludes the debate and the business of the session. The mini plenary will now rise.